This video is a follow-up, and so I asked Neurotranslator a follow-up question about the Florida Supreme Court's Task Force number 1 and Task Force number 2 on vexatious litigation. Florida has an ableism statute known as the Vexatious Litigant statute. The reason it's an ableism statute on its face is because it separates out the able people who are successful from the not able people who are unsuccessful. So on its face, it's an ableism statute because in order to designate and label a person as a vexatious litigant and put them on the Florida Supreme Court's lifetime vexatious litigant registry with no way off, such a poor sap who gets victimized by this ableism statute is labeled for life. And even in criminal cases, a person is able to get paroled, they are able to expunge, but not this ableism statute. Oh no. This ableism statute is meant to put labels that are very damaging for a lifetime. That'll impact background checks, the ability to get housing, the ability to get a job, and all sorts of things known as the Vexatious Litigant statute. And it designates people to this ableism statute to bar court access for a lifetime simply on the ableism criteria of counting up the number of the person's unsuccessful lawsuits. So I asked Neurotranslator about this. Here's the question I asked. Without taking into account what you just said, the Florida courts have enacted an ableism statute that simply counts up the number of unsuccessful claims and cases, and on the basis of that numerical count, locks autistic people out of court access and imposes punishments, forces us to have a neurotypical lawyer speak for our autistic viewpoint, where the lawyer has no autism training or understanding of autism and charges us tens of thousands of dollars that other people are not being charged. What is wrong with this, and how can this situation be fixed? And here is what Neurotranslator told me.
Mary Catherine, the situation you've described raises significant concerns regarding fairness, accessibility, and the treatment of autistic individuals within the legal system. Here are several key points regarding what's wrong with this approach and potential avenues for improvement. 1. Discrimination against autistic individuals. The use of an ableism statute that solely counts the number of unsuccessful claims without considering the reasons behind those outcomes can be discriminatory. It does not account for the communication challenges faced by autistic individuals, potentially leading to unjust barriers to accessing the court system. 2. Lack of understanding and representation. Requiring autistic individuals to work with neurotypical lawyers who lack training or understanding of autism can lead to a disconnect in communication and the representation of their viewpoints. This can result in the client's needs and perspectives being misrepresented or overlooked, impacting the effectiveness of their case. 3. Monetary barriers. Charging autistics tens of thousands of dollars intensifies socioeconomic inequality. It can discourage individuals from pursuing valid claims due to financial constraints, limiting access to justice for those who already face numerous challenges. 4. Need for accommodation. The legal system must recognize the unique communication styles of autistic individuals and implement accommodations that facilitate proper understanding and representation. This may include providing access to autism-trained legal advocates or interpreters. 5. Advocacy for change. To improve this situation, it's essential for advocates, legal reformers, and autistic individuals to work together. This could involve raising awareness about the specific needs of autistic people in legal contexts, pushing for changes in the laws and practices that allow for more inclusive and equitable access to the courts. 6. Training for legal professionals. Introducing mandatory training on autism and neurodiversity for legal professionals could help bridge the gap in understanding and communication. This training can create a more empathetic approach to dealing with autistic clients, resulting in fairer consideration of their claims. In summary, these practices can create significant barriers for autistic individuals seeking justice. Advocacy, awareness, and reform in the legal system are needed to ensure that autistic voices are heard and valued appropriately. If you have more insights on this topic or specific instances you'd like to discuss, please share.
So you have an alternative point of view from the autistic perspective on the Florida Supreme Court's Task Force number 1, Task Force number 2, and Florida's Abelism Vexatious Litigant Statute and Vexatious Litigant Registry. And that is, yes, it's an ableism statute. And for those of us who it has affected personally, it's wrong. The neurotypical ableist's viewpoint of courtroom capers. Well, there's another viewpoint. It is the autistic viewpoint. And it is just shocking and unbelievable that Task Force number 2 did not investigate the impact on the victims of this statute, the fact that it's going after autistic traits, characteristics, and autistic language. 3, that it's a lifetime designation with no way off. And 4, it's a segregation statute that has violated my rights under Title II of the ADA. And there you have it. More segregation, this time of autistic people, by the Florida Supreme Court. The clerk of the Florida Supreme Court, John Tomasino, and the Florida Supreme Court's Task Force number 1 and Task Force number 2 on vexatious litigation. Vexatious, also known as autistic litigants denied autistic translators in their court case. So, this statute is created by ableists. It's an ableism statute. It counts up how many unsuccessful cases that you have. If you don't have your autistic translator, you're going to have an unsuccessful case. If you like my videos, please hit the subscribe button and ring the bell, and you'll be notified of my future videos, and thank you for watching.